Today, we're discussing managing workplace investigations. We are going to take you through the steps of an investigation from screening that initial complaint to collecting the evidence and then ultimately preparing an investigation report. And we'll also review issues that you can encounter at various points along that journey. My name is Dorian Persaud. I am the senior lawyer at Persaud Employment Law. We are a team of lawyers that specialize in conducting workplace investigations and helping you to build healthier workplaces through investigations, training, and proactive advice. So it's easy when you receive a complaint of misconduct to jump straight into that and make that knee-jerk reaction like, okay, I got to rush off and conduct an investigation. The first thing that you want to do is to screen the complaint and ask yourself a few questions first to determine what response is required for that particular circumstance. So when you get the complaint, you want to ask yourself, look, do these allegations, if they're true, would it violate any of our workplace policies? Or, this behavior, maybe it doesn't violate a workplace policy, but it is risky behavior that could give rise to some legal liability on the part of the organization. And if those conditions are met, that might be a reason that you might want to look further into the allegations of misconduct. And then a final question that you want to ask yourself at the screening stage is there the potential here for the violation of any piece of legislation, including the Human Rights Code? So we've got legislation at both the federal and the provincial level, occupational health and safety legislation that would require an employer to look into allegations of harassment, sexual harassment, and discrimination, and then human rights legislation as well that will specify the obligation to look into allegations of discrimination that are presented to an employer. And in terms of that duty to investigate, even before we had legislation at the federal and the provincial level, human rights tribunals across the country had articulated this obligation for employers to the extent that even if there wasn't actually any discrimination going on, if an employer was presented with a complaint and just didn't take any steps to look into it further and dismissed it, maybe because they thought, there's nothing here for me to look into, because we know we've been doing things in the right way. Even in those situations where an employer didn't do anything wrong, there's no discrimination, but they haven't even looked into the complaint, there are decisions such as the one that we presented on this slide that illustrate, for that failure to investigate, employers could be held liable. So this is an obligation, that duty to investigate, that's existed for some time. And as an employer, you want to make sure that those conditions are met before you jump into the investigation. So you've gone through that screening step. What comes next? Well, you have this complaint, you've made the decision that, yes, this requires an investigation, and then you want to meet with the complainant or the individuals that have come forward and make sure that you understand their story. One of the mistakes that we often see made is folks assume that because they have a complaint in writing, that those are all of the allegations, or those are all of the details that they need to then begin conducting interviews, whether with the responding party or with witnesses. And at that early stage, they don't circle back with the complainant just to confirm that they have a proper handle on that individual story. So you want to make sure that you don't make that mistake, make sure that you get the story, and then move on with your investigation. Another step that we often see skipped is drafting what we call the particulars of complaints. So we have a list of allegations with enough detail in there for the responding party to give an answer to the allegations. So the level of detail you want to think about is, who's involved and what is alleged to have occurred and roughly, when did these incidents occur? Again, you want to approach this from the perspective of if you were the responding party, how much detail do you need to step into a meeting prepared to give an answer? We like to prepare the particulars of complaint and then provide them to the responding party with sufficient time for that person to come to a meeting prepared to give a response. There is another view or another approach here where some folks prefer to essentially call the individual into a meeting and then present them with the allegations and get their response in that moment. Some would refer to that as an investigation by ambush in a sense. And again, there's a view that you get better evidence that way. It's always our view that it's, that's really difficult to get the best evidence in that circumstance. And I can only speak for myself that it's difficult to remember what I did last week or a couple of weeks ago, never mind go back to events that may have happened several months ago and try to piece together the communications on a particular day. So with that in mind, we prefer to allow the responding party time to sit with the allegations, go through their emails, go through their notes and records, and really come to that meeting prepared to give a fulsome response. Another step here that you want to make sure that you're clear on at the outset of the process is your mandate as the investigator. And oftentimes we see investigations go off the rails because folks don't have a clear idea of what it is that they're supposed to be investigating. And so let me give you an example. We are in the process of investigating a complaint of bullying and harassment from several staff members against their manager. And in the process of conducting that investigation, it recently came to our attention that some of these same complainants were experiencing sexual harassment. So not from the same manager, not from the same responding parties in that initial investigation, but from another colleague at work. And when you receive allegations of sexual harassment, it would be easy to say, okay, well, that obviously violates a policy, and this would easily be something that the client will want us to look into. So let's just jump in and look at that issue too. But that would have been a mistake. And so what we did is to, at a high level, collect some details that were being communicated to us, and then go back to the client and say, look, some of the folks that we met with have come forward with fresh complaints of sexual harassment allegedly involving this individual. How do you want us to handle that? And the client then has the ability to say, yes, Dorian, go ahead. We want to expand your firm's mandate to look into that issue as well. We think that's going to be the most efficient way forward. Or they might say, we're going to treat that as a separate investigation, and maybe that's something that we're going to handle in-house, right? There are any number of ways that this can play out. But the key thing is that, whether you're an external investigator or you're handling this internally, you don't just run off and pursue every allegation of misconduct that comes your way. You're really focused on, what's my mandate here? What is it that I am charged with investigating? And you're really just focused on meeting with the individuals and the witnesses and collecting the evidence that deals with that particular allegation. As you get into the process and you're initiating this investigation, one of the issues that will come up is confidentiality, and you'll want to remind folks early on in the process about the expectations regarding confidentiality, and that individuals are not to discuss the contents of what they're going to be discussing with the investigator with others at work or connected to the workplace. So all of these allegations and details related to the investigation, those are just being discussed with the investigator. We're not having these conversations at work and allowing that gossip to fester. You want to, again, set that expectation early in the process, but also find out when you begin the interviews whether or not folks have already had these discussions, and we're at the beginning stages of an investigation now where there are more than a dozen complainants who have come forward with a complaint against a senior administrator. But as it turns out, many of these individuals got together beforehand and they brought their complaint forward as a group. So they had a group discussion about their individual grievances with this administrator, and then came forward and brought their concerns, expressed their concerns about his behavior. So as an investigator, you want to flesh that out a little bit, right? You want to know, look, to the extent that these discussions have taken place, what impact does that have on the investigation? Did these folks, for example, coordinate their evidence, right? So did they have where there are maybe 2 or 3 people at a meeting where something inappropriate was said or done? And did these, 2 or 3 people then get together and say, okay, here's what I recall, here's what you recall, and that they then coordinate their evidence to make sure their stories matched? If that happened, that has consequences for the how you investigate those allegations and the credibility of the individuals involved. It may be the case that folks got together and there was a general discussion about, hey, I experienced problematic behavior as well, and everyone kind of has a different experience. So it wasn't necessarily a coordinating of evidence, it was more sharing their experience and saying, yes, they too have had problematic interactions with this individual, and then coming forward to file their complaint. So you want to make sure you have a handle in terms of what you're dealing with. Another issue around confidentiality is just making sure that you're making it clear that folks are to preserve evidence. So don't delete any text messages. Don't delete those photos on your phone. Make sure that you're preserving that, because all of that information is relevant for the investigation. We had a situation a while back where we were investigating in the middle of an investigation, and it turns out our client had a laptop from a former employee. That laptop contained information that was relevant, and that laptop was wiped by the IT folks. So it didn't impede the investigation to the extent that we were still able to go ahead and do our work and make the necessary conclusions in that case. But it certainly would have helped to have some of the documents that were stored on that laptop. So sometimes, things that seem pretty obvious on their face aren't obvious to everyone that's involved. So you want to make it clear that that there isn't to be any deleting of information. Do not wipe things from the server. Don't wipe the laptops. Keep everything intact, at least until the investigation is over. That brings us to collecting evidence, and the primary source of your evidence is going to be through interviews with the parties and the witnesses involved. One of the new developments in terms of investigations that we've seen is many of these investigation interviews are being done in a virtual setting like this one. And so we're on Zoom or Teams and conducting these interviews. So you don't beforehand, you would know, hey, I'm just sitting in a boardroom with this individual. We know that this is a confidential meeting, but when you're meeting virtually, you don't necessarily know that. So you want to ask those questions to make sure that if anybody else is in the room. You want to make sure that the other party isn't surreptitiously recording the interview, and you want to make sure that you're able to preserve confidentiality even in a virtual setting. We find it helpful to record investigation interviews and prepare an accurate transcript of that event. In addition to recording the interviews, we'll also be typing our notes as well. And so that way, if there's an issue with the recording, at least you've got your typewritten notes to fall back on. But it's important to have a recording of both the questions that you're asking and the answers that you're being given. We've seen many investigations where clients come to us asking for help to troubleshoot an issue with an investigation. And it's really difficult looking at the notes to figure out what question was asked to elicit the answer that was given, and that makes a big difference when you're trying to pull everything together and figure out, is this an admission of some sort, or what exactly am I dealing with here? So we like to prepare an accurate transcript of the interview, and we'll have the witness sign off on that transcript just to make sure that at the end of the day, they're not going to say, oh, you know what, I didn't actually say that to the investigator, or here's what I actually meant to say. You want to make sure that you really have them tied down and committed to what you have in writing there. Another point when it comes to collecting the evidence is making sure that the responding party, again, has the details of what they're accused of doing well in advance of the interview, and giving them an opportunity then to prepare and attend that interview with their notes and all of the evidence that they're going to be relying on to present their case. So you want to, again, give enough lead time so that it's not just being presented with the allegations, but being able to actually go through and organize their notes and prepare a little bit for the interview. How much time they need to prepare really depends on the circumstances. We had a rather complex investigation where there were more than 20 allegations from 8 to 10 different parties against this professor, and so we gave him almost a week to prepare for those interviews, again, just because of the volume of allegations and the number of people involved. It required a significant amount of prep. In other cases, 24 to 48 hours is enough time. So it really just depends, again, on the specific context that you're faced with. When it comes to collecting evidence, at some point you're going to have to reconcile that evidence. So you're going to have the complainant's point of view, and you're going to have the respondent's point of view, and you're going to have to somehow look at these stories and figure out where do they agree and where do they differ, and to the extent that they differ, how do I resolve those differences? And that would involve oftentimes reviewing documentary evidence and emails and text messages and meeting with witnesses to figure out what actually occurred. So you want to make sure that you're able to keep track of this evidence, and we find it helpful to prepare an evidence chart so we can track all of the allegations as they're communicated to us, that we can summarize the evidence that we're collecting as we go along, and then at a glance, we're able to see, okay, for this particular allegation, there's a gap here, and we need to resolve that. That would warrant us, again, taking steps like meeting with a witness or several witnesses, or reviewing documentary evidence. So if you need help with that analysis piece, we do have a tool, an evidentiary summary tool that we use. It's a very basic Excel template, but it's set up in a way that allows us to go over what we've collected at a glance. If that's something that would be helpful to you, please don't hesitate to send us an email. We'd be happy to send you that tool. When it comes to analyzing the evidence that you've collected in an investigation, you want to make sure that you're aware of the standard, the evidentiary standard that you're trying to meet. So oftentimes we have bogged down thinking, look, I don't really know what occurred here, and you're trying to prove this thing beyond a reasonable doubt. You want to know for certain whether or not a certain thing was done or a comment was made. And it's important to recognize that the evidentiary standard here is on a balance of probabilities. And so another way that test is articulated is, is it more likely than not that this thing occurred? Or if you want to put a percent to it, it's 50% plus 1, all right? So you're just looking for a little bit of evidence, or enough evidence to kind of tip that scale one way or the other. And that's the civil standard of proof that's required in the circumstances. You don't need to know for certain whether or not something happened. And that usually stirs a little bit of unrest in many of us, because it means that there's a possibility that we may get it wrong, right? When you're looking at this thing on a balance of probabilities, there is a chance that you may make the wrong conclusion. And that's a fact of doing this work, and something that you need to be comfortable with as you're doing this work. You're not going to get it perfect. but you want to make sure that you are going through a process that will stand up to scrutiny, that you're interacting with the evidence in a meaningful way, and ultimately using good judgment to arrive at a conclusion as far as whether or not something happened. In many of these cases, when it comes to analyzing the evidence and making a conclusion, it comes down to credibility. You may not have that smoking gun, so to speak. You don't have that text message or that email or that key witness that's going to put it all together for you. And some of us aren't very good at assessing credibility, and you might get distracted by how confident a person speaks, or whether or not they're making eye contact with you when they're speaking, and how persuasive they sound, and whether or not they were sweating, and were they fidgeting when they were giving their answers, right? We look at all these cues from body language, and it's not to say that those cues don't have their place and aren't relevant in the analysis, but they come on the back end of the analysis. The main thing that you want to look for is the harmony of that person's evidence with the rest of the evidence that you've collected. And the leading case for this test is, or the best articulation of this test, it comes from the case of Farnia and Chorney, where the judge says, like, don't be distracted by the way that a witness might behave on the witness stand. The truth of their story has to be, whether or not their story is in harmony with the other evidence that you've collected, and would an informed person in that place, in those same conditions, recognize that the consistency, and ultimately you're looking for, does this story make sense when you put it all together? So that's what you're aiming for. Let me give you an example of that. I conducted an investigation where the parties worked in a manufacturing facility. So they worked on the shop floor. And I walked the shop floor, and you couldn't hear what someone was saying if they were standing 2 feet away from you. It was that loud. Unless the person was right beside you speaking, you would not overhear a conversation that was happening just a couple feet away. And this was a case involving allegations of sexual harassment. And so the worker and the complainant in that case, she said she was propositioned by her supervisor that he kept making these overtures to her. She denied him. And as a result, he took away shifts from her. So she experienced a decline in her income because she wouldn't play ball with him. And it was literally a he said, she said scenario. He said that this was all fabricated, that he didn't know her from any of his other workers. She was just one of the employees that reported to him, and he didn't have any significant or meaningful interactions with her, and certainly did not proposition her in the way that she had claimed. And her evidence was quite the opposite. And one of the things that we then did to reconcile this was to ask her about some of the details that she knew about this manager. And she was able to recount things like his relationship with his wife, and how many kids he had, and the fact that he had just purchased a house, and how much the house cost him, and other pressures that were that he was faced with in his life. And when you hear those details, and those intimate details that she was recounting, it was obvious that if this were true, there was more here to the story than what the manager was saying. Because again, according to him, she was just one of several workers. She wouldn't know about the details of his relationship with his wife, and how intimate or not they were, and what he paid for his home, and other such details. So we met with him again in a follow-up interview to put these details to him and give him an opportunity to respond. And he didn't have an answer that was convincing to me. So we made a determination that she was more credible. She was telling the truth. And that made sense based on the other documents we put together. So we were able to demonstrate that, yes, here's when the propositions were allegedly made. And here, based on her schedule, you can see the decline in shifts, or she used to be awarded overtime shifts. And now after after turning down her manager, you can see a decrease in those shifts that she was assigned. And then you can see what's happening within the business itself. There's records to demonstrate that the business was pretty stable. There wasn't any big drop off in production that would then warrant a drop off in terms of the shifts that she was assigned. So you have to put the pieces together, and it isn't easy to do. Uh, it does require some hard work and insight, and you have to be able to understand the nuance of the situation and know what to ask and follow those instincts. And so these are things that I've developed just by virtue of litigating a large number of cases. And so these are things that we as lawyers get to work on more frequently than a layperson. But it is a skill that you can learn and develop. And so that was what we applied in that moment, in that case, to get at the right result. So again, some cases will come down to that level of detail, and knowing how to make a sound credibility assessment will help you to do a good job doing this work. In terms of pulling this all together, you have to look at all this evidence that you've collected now and make sure that you've proven all of the elements then to reach a conclusion. So the first thing you want to look at is, did this thing occur? Were these comments made that were as alleged by the complainant? If those comments were made, do they constitute harassment or sexual harassment? Do they meet the policy definition for that? And is the responding party the person that made the comments and engage in this problematic behavior? So you want to make sure that you've covered all of those elements before you make a conclusion. And then finally, you're going to report your findings. So you want to make sure you pull all of this together and document what just occurred in the process. And in terms of pulling that together, one of the things that you want to look at is making sure that you've interviewed all of the relevant witnesses. We've had cases where after the fact, someone's not happy with our conclusions, and they say, well, Dorian, I gave Dorian 5 witnesses and he never interviewed any of them. And so you want to make sure as an investigator, you've interviewed the people that you need to meet with. And so if there are witnesses that were suggested to you and you didn't meet with them, you want to make sure you document a rationale for not meeting with them, not necessarily in your report, but just for your records. And so I'll give you an example of that might be the witnesses that were suggested to you. Maybe they were character witnesses, right? Someone saying, hey, Dorian, you need to meet with these people because they can speak to the kind of person I am. I would never do the things I was accused of doing. Well, that's not a reason to meet with a witness, right? You're looking to meet with individuals who witnessed one of the events in question. So maybe they can speak to what actually occurred. Maybe they observed some aspect of the relationship that's helpful. I interviewed the superintendent of a school board recently in a racial discrimination case because I wanted to know what discussions he had with senior administrators about the issue of racism in the school. There was again, it had come up in the evidence that there were some discussions at a higher level, and that individuals were seeking support from the superintendent and other staff. So we met with those individuals, right? So the people that you meet with have to bring something to the table. There's some light that they're going to shed on the issue of what happened. You're not just meeting with individuals just because they were suggested by one of the parties. Having said that, if when you look at the witness list, if you've only met with one party's witnesses and not the other, you want to ask yourself again, why is that the case? And if some of the complainant's witnesses were observed relevant interactions, and then there's no reason why you don't want to have a balance, right? In terms of having met with some of those folks. If not for any other reason than to establish that you approach this in a balanced way. And maybe they're just going to reinforce what other witnesses have said. But again, it's just about making sure that the process you undertake, it's free of bias and also free from the perception of bias. And so there may be some interviews you have, again, just to satisfy that condition that, yes, I've met with everyone and I've been fair to both parties. And you want to make sure you summarize that evidence in your investigation report. And that way, when someone's reading your report and they see the allegation and they see the conclusions, you want to make sure there's enough evidence there that helps them figure out how the investigator got to the bottom line. There's enough evidence summarized there that explains your rationale for arriving at the conclusion that you did. And the final point that we have on this slide is, did you test all the evidence or pro inconsistencies? You often don't have perfect witnesses, right? You've got witnesses who are credible. You believe that they have told you the truth, but there may be some inconsistencies there. And we had a case where a complainant in a sexual harassment case, she described this interaction that she had with her professor, and she described how terrified she was in the moment, and she immediately spoke to another student in the class that she happened to be partnered up with at that time and said, hey, don't leave the room again, because when you left the room, here's what this person said to me. And when we met with that witness to verify this story, he had a completely different recollection of the event. He's like, yes, I do remember the complainant telling me that the professor made a comment when he left the room, and that she was terrified when this witness got back to the classroom, but he's like, she said something completely different. So there's an inconsistency there. So we went back to the complainant to put this to her, and she said, you know what, I would trust the witness's recollection of it. He would know for sure. She indicated that that event she described to us did happen, but it may have happened afterward or at a later date. So the event happened, it just didn't happen in the order in which she told us. And that made sense to us because we knew that she was traumatized based on the sexual harassment that she had experienced, and that is consistent. The lack of that inability to put things in perfect sequence is consistent with the symptoms that we see of someone who has suffered trauma. So we were able to reconcile that inconsistency and make our conclusions accordingly. But it was important to do that in that case because, as you can appreciate, the responding party, after we summarize the evidence and you can see this inconsistency, it's one of the first things that the responding party is going to jump to, is to say, look, this person got it wrong. How could you believe them? And so you want to make sure that, again, you've thought through these issues and that you've documented your rationale and that you've reasoned through the issue and arrived at a conclusion that makes sense. I can't tell you how many times we've seen a client go through an investigation and then they come back and they throw their hands up and they say, we're not really sure what happened here. We can't reach a conclusion, or maybe they retained a third-party investigator, and that investigator's come back and thrown their hands up and said, you know what, we're not really sure what happened here. It's just a he said, she said situation, and we don't have any evidence to bridge the two, so we can't make a conclusion. For us, that's a cop-out. You can't not make a conclusion. You have to make a finding. So you need to wrestle with the evidence. You need to go back, figure out if you missed some details, and again, do the work that needs to be done to arrive at a conclusion on a balance of probabilities. And if the event happened, it happened, and then then the next step is there a policy violation? If it didn't happen, or didn't happen maybe in the way that was communicated, again, you're outlining and indicating that in your report as well. And then in terms of that report, you're usually going to have a detailed report that outlines everything that you did, the way that you conducted the investigation, all of your evidence, and all of the conclusions. And then you might have a scaled down version for the parties where they might just get the conclusions of the investigation, or a report that is redacted so that the names of witnesses isn't shared, and they don't get a copy of all of the evidence that you may have collected in the course of the investigation. So you'll want to be aware of what the reporting requirements are in based on your organization's needs and based on the legislation uh, that might be setting the rules for your workplace, be that federal or provincial legislation. So I hope those insights are helpful to you in terms of not just the investigation process, but just the issues that you can encounter along the way. And I want to open up the floor now to answer any questions that you might have about the information that we presented. Please do use the Q&A function in Zoom to pose your questions. We also want to make you aware of the training seminars that we have on this issue. So we have a 2-day seminar on how to conduct a workplace investigation, and we have dates coming up in the summer and in the fall. So if that's something that's of interest to you, where we're going to go through a scenario, a mock investigation, you're going to have the case scenario. We're going to interview a complainant and the respondent and relevant witnesses. We've got live actors that play those roles. You really do get to examine these parties and see how to do that, how to conduct those interviews properly, and mistakes that are often made in conducting those interviews. So you do get the benefit of that interactive experience. And then, like I said, we'll take that evidence and complete that arc of the investigation to analyzing that evidence and drafting an investigation report together. So we hope that would be something that would be helpful to you, and would ask you to consider that and send us an email if you'd like more details.
Dorian, we do have some email questions in, so if you don't mind, I'll pop those in here.
Wonderful.
Okay, and the first one is, what is the customary time an investigation should take? Is there a maximum and a minimum?
That's a great question. And I think we're actually going to do probably another webinar on this topic of the arc of an investigation, and because there's certain things that can happen along the way in terms of illness and family emergencies that really can delay the process. But I would say on average, most investigations are driven by the number of parties and witnesses involved, and because ultimately you got to schedule these interviews, and those folks have to be cooperative. And we had so in theory, you might have an investigation that should take 2 months, but if you've got, we had an investigation recently where some of the parties were represented by an advocacy group, and this advocacy group refused to acknowledge any obligation regarding confidentiality. So instead of being able to conduct these interviews via Zoom, we had to meet with them in person to ensure that there wasn't going to be a live broadcast of the investigation interview on Facebook Live or some other social media platform. And then in terms of scheduling those in-person interviews, then you're dealing with when they're available and where they want to meet, and all of these issues. So they really dragged out this process where just scheduling a meeting with this complainant, who was making serious allegations of racial discrimination, by the way. So it was on the this more serious end of continuum of bad behavior. They took almost 2 months just to schedule that initial interview. So and these issues occur during investigations. So in terms of how long investigations take, again, they're driven by the number of parties involved and the cooperation of those parties in terms of scheduling these interviews. But we completed an investigation over the Christmas season involving a dozen complainants and one respondent, and that entire investigation was completed in 2 weeks, simply because everyone was available. And we were able to meet and get these interviews done, stacking multiple interviews on the same day. And it was important for the parties, it was important for the clients, and we got the cooperation of everyone involved. So so just because you have a number of individuals, that doesn't mean that it takes several months. Like I said, it could take as short as a couple of weeks. a lot of it's driven by the cooperation of the parties and just the availability of individuals. But on average, I always tell clients, budget at least a couple months for an investigation. And in some complex ones, we have been part of investigations that have been, 3 to 6 months, I would say. But that would be the normal range if I had to provide one. But there's so many different variables to this work. It's really hard to give a hard and fast standard.
Okay. The next question is, when do you perform a follow-up interview with the claimant?
So after you've met with the responding party and met with some witnesses to resolve, to maybe fill in any gaps in the evidence, you go back to the complainant and at that point and give them an opportunity to address any inconsistencies, in their evidence or contradictions between what they initially told you and the information that you've subsequently collected. So that would be one of the final steps before you conclude the investigation.
Okay. Next question is, you indicated a practice whereby you inform the accused of the allegations so that they have time to collect evidence, formulate a response before the meeting. What is an appropriate time frame to give them, and how do you mitigate risks of potential retaliation when taking this approach?
Yeah, so there's a couple things in there. Number one, when you're conducting the investigation, you don't want to necessarily have the parties reporting to each other during the investigation, right? So you're looking at the beginning of the investigation, what are the interim measures that are necessary here? Do we keep the parties at work? Do we ask one party to work from home? Do we set up an interim reporting relationship, right, where if it's a subordinate against his or her manager, there's another person that's inserted to kind of be the acting manager for that employee for the time being. So those are things that you want to turn your mind to and set up those interim measures at the outset of the investigation, so that in the middle of an investigation, you're not worried about retaliation, right? Like those are things that you've thought about at the beginning of the investigation. Can you carry on an active workplace investigation and still have these parties, working and interacting with each other? So there's got to be some planning that's done earlier on, and by the time you then get to giving the responding party details of the allegations, you're not really considering retaliation at that point, because you've already dealt with that issue. So now you're just focused on how much time do they need to prepare for the meeting. And I would say for that, in terms of how much time they need to prepare, that's really going to depend on the complexity of the allegation. So if you're asking them to go back to meetings that they had 6 months ago, and when they were maybe performance managing an employee, and what was said and what was done, the manager, if that event happened 6 months ago, is not going to remember a lot of those details, and so they might need at least a couple days to go back and dig up their notes. We had an investigation involving a responding party who was a professor, and there was more than 20 allegations, and they were coming from 10 or 12 different complainants, and these events occurred over a period of 2 years. So again, just the fact that you're asking someone to go back into their records 2 years and then go through that volume of allegations, we provided him with a week to do that. And it wasn't a hard and fast deadline, but we just thought that was a reasonable amount of time for him to prepare. And if he needed more time or less time, he could let us know. So it's something that's fluid in terms of, and really contextual, right? You're kind of just doing what makes sense in that moment. But at the end of the day, it's about fairness. What you don't want is for someone to say, look, I participated in this investigation and I didn't have any time to prepare, and I lost my job as a result. And had I been given more time, I would have been able to show my employer, this email and provide this documentation, and I had this evidence to show that I didn't do the thing that I was accused of doing, right? So as an employer, at the end of the day, you don't want to be fixated on the time. You want to be fixated on a fair process that's going to stand up to scrutiny, because on the back end of this, it's a high stakes event. Like someone could lose their job, and so you want to make sure that if you're making a decision to let someone go based on these conclusions, that you've got a process that you know is going to stand up to scrutiny.
Okay. Another email question in the same email. Are there any templates for the findings reports?
We do have a template that we can modify and provide to you. So yeah, certainly if that's something that others want, please do send us an email and we can provide you with a template that outlines the sections that you should have in the report and just to make sure that you've got everything covered. So yeah, please do shoot us an email and we'd be happy to provide a template for you.
Yeah, actually, you can also just put it in the questions. Just raise your hand or write template in there. Yeah, there you go. Thank you, Lisa. Okay, are there any other questions from the attendees here? If there are, just go ahead and, okay, there we go. When you speak of scrutiny of the investigation, what do you mean?
So after you conclude the investigation, you're going to get questions, right? And those questions might come from the employee. Let's just say they're disciplined or they're dismissed because of the allegations and the conclusions. You might get scrutiny in terms of a letter from that employee or a letter from the lawyer saying, you know, my client wasn't treated fairly. In most of the cases that we do, in many cases, you know, there's it is a public sector employer. It's a unionized workplace, and the employee has the right to grieve that decision. So they've been disciplined because of the findings, or they've been dismissed, and then they're going to the union is going to file a grievance and say, look, this person wasn't treated fairly, and they're entitled to have their job back, or this punishment was too strong, and so look at this investigation that was done; it was flawed in some way. Like my client my client wasn't given an opportunity to speak to these allegations, or the investigator didn't meet with the right witnesses, or the investigator didn't consider this piece of evidence, right? So that sometimes, just for the sake of just trying to make a case, they're going to look at the investigation and try to poke holes in it, to say, look, because you did a flawed investigation, you can't rely on that investigation to support the termination of this employee. So that's something that employers need to be aware of when they're going through this. Again, we only get involved in not only get involved, but oftentimes we're involved in complex cases, right? So it's these very contested cases where there's serious allegations that are made, and you can be sure someone's not going to be happy on the back end of that. So whether they're going to court and trying to sue the employer for wrongful dismissal, or they're going to arbitration to try to undo discipline or dismissal, the investigation report becomes a key piece of evidence in terms of, was the employer justified in taking the steps that they did. There's a case that just came out involving Royal Bank of Canada, and they let their chief financial officer was dismissed for just cause, and that was because she was involved in a inappropriate workplace relationship, and she allegedly gave preferential treatment to this other RBC employee that she was involved with, right? So it's not just the fact of the relationship, is that she gave preferential treatment to that individual, by way of promotion and bonuses and things like that. So that's a case where there are literally millions of dollars at stake in terms of whether or not, whether she gets a severance package or is dismissed for just cause, in which case you don't get anything. And you can be sure that if she and her lawyers decide to push her case forward, one of the things that they're going to be contesting is the investigation, the conclusions of it, and whether or not RBC was correct to find that there was this preferential treatment given to this other individual. So that's an example of how the investigation becomes a key piece of evidence that is, like I said, one party has an interest in trying to undermine in order to advance their case.
Okay, I think this is the last call for questions. We got quite a few requests for templates if you didn't realize that, Dorian. So as soon as you have that ready, I'll make sure they get sent out. Any other questions? This is last call. We'll give you a minute. Okay, a few more templates. Let me make sure. Okay. Let me just get those down. Dorian, if there's anything that you'd like to say while I finish up getting these folks information, that would be great.
I just want to thank everyone for your participation. And I think through the questions that we got, and then through the presentation itself, you can see how important it is in some of these complex cases to really have an understanding of you can see the role that litigation plays in terms of the conducting the investigation, and that's the strength of the way that we approach this work, having litigated a number of cases, and now when we approach an investigation, it's through that litigation lens, knowing that the investigation results might be contested. And so when we're setting up the investigation or and then conducting the investigation and all the little decisions that we make along the way, it's with that end in mind that at the end of the day, we want you to have a product that's going to stand up to scrutiny. So we hope that we've passed on that insight today, so that as you're going through the process, you can be diligent as well in terms of just following those steps that we've outlined, and making sure that you are paying attention to the right things. And by doing that, even if folks raise questions, you're going to have a process that stands up to scrutiny. So you don't have to be perfect in doing this work. We're not aiming for perfection. We're just aiming to be reasonable and be diligent. And if you follow the steps that we've outlined, you'll end up in the right place. So thank you very much for joining us today, and we hope that you'll join us for our webinar next month. You'll be getting an email notification about that. If you've enjoyed these webinars, please send us an email and let us know that you appreciate this content, and if there if there are other topics that you want us to cover, again, let us know that as well, and we'd be happy to prepare those materials for a future event. Thanks very much, everyone, and wish you all the best.